My name is John Koda, and I have filled out a speaker's card. As was noted, I was with the Boone firm for 25 years, and this is my first opportunity to be in front of you all, so thank you. Here representing the applicants. My role this evening is just to take a few minutes and do a few things prior to getting into the nuts and bolts with the environmental specialist, Mr. Browse. I'm going to do a short bullet cap recap of the application as it stands, as we see it. We'll do a brief history of the land. You already discussed that to a certain extent. And third, we're going to preempt and address a few what we think are misstatements and misapprehensions contained within the infamous Stop the Swap petition that's being circulated. You ready? Okay, slide one. As for the property itself, we know that the Commission and the planners don't like to use the word swap, although I've heard it mentioned a few times already. But I understand why, but in this case, I think there's an argument that the term is inapplicable anyway, because our clients really aren't seeking to swap equal land for equal land. As I see it, their proposal actually provides a means by which the county will receive a greater level of benefits and protections for environmentally sensitive property than would be the case if the application had not been submitted at all. And I think that's something that Mr. Browse is going to touch on in a little bit regarding the planner's conclusions for this proposal. So I'm going to belabor a little bit of what's already been discussed. What our clients propose is to have a 1.43 acre parcel here, which is most of which is designated wetlands, rezoned from more intensive RSF1 to less intensive OUC. They would also have another smaller parcel of upland property of just over 1 acre, rezoned from OUC to RSF1. If we're going to call this a swap, then it benefits the county and the environment, in our opinion, because it means that almost 1.5 acres of designated wetlands, or whatever the amount might be, it's significant. It will now be zoned OUC, while a much smaller parcel of approximately 1 acre will be zoned RSF1. And this area that we're seeking to have rezoned is upland. And again, only one single family home is going to be constructed on that entire acre. So let's go back in time a bit. This is a 1957 aerial photo showing that before the improvements to Laurel Road and before the Prinebrook Road, before the Albee Farm Road was extended to meet it, there was a graded access path accessible from the southeast. All that area in white that you're seeing the cursor go across now was upland. Next slide. In 1974, by 1974, you can see that a portion of that southern boundary of the property was no longer graded with access to the consistently dry upland area, which is the area my clients would like rezoned. Access at that point was achieved from the north off of Laurel Road. And then again, we talked about this a little bit. By 1988, things had changed rather drastically because Laurel Road was improved with stormwater features, including a drainage easement at that time. So the effect of that, we think, was to essentially inundate the area formerly used for access, which cut off access from Laurel Road. Again, however, the area our clients seek to rezone to RSF1 was and is upland. Our clients researched the history of the parcels and discovered that back in 2006, a former prospective purchaser of the southern parcel submitted a site plan utilizing existing zoning classifications. So the home site that was proposed at that time within the wetlands area and the long dock had a long dock going out to Shackett Creek. Our client's proposal is on the right, and the next few slides will show you the difference between the two of them. The next one here, this is the 2006 proposal, a whopping 28,717 square feet of impact to wetlands. In contrast, our client's proposal impacts less than 5,000 square feet of wetland, and most of that is near the entrance there off of Pinebrook where the driveway begins. And the last slide regarding that previous feature, it just shows a bar graph showing the difference of wetland impacted lands between those two proposals. And this is important. We do respect and appreciate the right of neighboring property owners and concerned citizens to speak to you here today, but we do want to make sure that the justifications for getting people's attention on this are accurate, and we do have some few bones to pick with regard to the petition that has been circulated, and just wanted to take a minute to discuss that. The first one suggests that our clients are requesting rezoning from Sarasota County and a swap of land from, quote, OUC wetland to RSF1. That's inaccurate. The OUC area requested to be placed in RSF1 is high and dry. It's not wetlands. This petition actually places much more wetlands into OUC, and the disturbed uplands area, overgrown with invasive vegetation. And again, this proposal would provide almost a half an acre more into the OUC designation than currently exists. Next one, and I think the next two points relate to the proposed driveway and the bridge, which the petition suggests is that they don't meet federal standards. Our legal analysis indicates that a private driveway to a single-family residence is exempt from compliance with federal roadway standards in this context. And it's already been corrected that the driveway width would not be 20 feet. It would actually be only 10 feet wide. And that kind of bleeds into the last point, which is that the permit these owners have the suggestion is in the petition that the permit that my clients have submitted is non-binding, which means they are not restricted to the amount of building they can build on the property. Again, we beg to differ. It is. It's restricted to one single-family home per the zoning. Any further residential construction would require a different road, a different driveway design, different permits, far more complicated, environmentally sensitive, invasive process.
The applicant opened with a statement calling equal land for equal land. I think that's just a miscategorization of what's happening here. The only thing equal in it is about the relative size. And to state a measure that you're going to take these two parcels that have nothing built on it and then you're going to build something on it and it's better for the environment is kind of a stretch. And you don't see the evidence of that really coming out in the application itself as it relates to the goals, objectives, and policies of the comprehensive plan. So, however this vote falls, it's going to move forward to the county commission one way or the other. And I think falling on an argument of equal land for equal land doesn't hold up under the goals, objectives, and policies of our comprehensive plan. So with that, I will call the question. All those in favor of a motion to deny, please signify by saying aye.
Aye.
Aye. Any opposed? Chair votes aye. Motion carries unanimously.
Thank you.